but the validity is of 30 days.
Miss Akanksha, you can start. We have started the streaming.
Sure. So I was giving the instruction before we start the session. With Sudhar sir, with your permission, shall I start the session?
Yes, ma'am, we can proceed.
Sure. So I'll just go with the intro, but before that, I was just giving the instruction to the participants that every weekend there will be the class from 6:30, and the recordings will be provided with the validity of 30 days. The notes and everything will be provided. If we like receive the PPT, we'll send it to everyone. And after the completion of the course, the certificate and rest of the material will be provided. So, it is with your permission, sir. I would like to go ahead with your intro, and then we'll move forward for the session.
Oh, ma'am.
It is my privilege to introduce an accomplished professional, entrepreneur, and legal academician, Advocate Sudhar Pandey, sir. With over a decade of diverse experience in business development, career consultancy, legal content development, and education. Mr. Pandey has emerged as a remarkable force in the field of legal and competitive exam preparation. Advocate Pandey's journey is one of the relentless passion, innovation, and success. As an entrepreneur, he has established and successfully grown multiple business in the education sector, helping countless students achieve their dreams of excelling in competitive exams. Particularly in law related fields, he has been instrumental in pioneering programs for CLAT, judiciary exams, and other competitive avenues, equipping students with the tools they need to succeed. Throughout his career, Mr. Pandey has collaborated with reputed organizations such as Time, Career Launcher, and Rustum Legal, serving in diverse roles including faculty, content developer, business partner, and marketing head. He has developed top-notch content for legal reasoning and major law subjects like CPC, CRPC, IPC, IEA, and the Contract Act, benefiting thousands of students across India. One of his notable contributions is the development of legal reasoning content for time on a pan-India basis, helping over 50,000 students from 2018 to 2020. His expertise as a faculty in legal aptitude and general knowledge has directly resulted in the success of numerous students who are now thriving in national or universities and judicial services. Honorable Sir's work has consistently showcased his commitment to innovation and quality in the field of education. His ability to motivate and train sales and academic teams, coupled with his in depth market analysis, has ensured the growth and stability of the education firms he has been associated with. Known for his dynamic personality, outstanding communication skills, and a highly degree of personal integrity, Honorable Sir is not only a mentor to aspiring professionals, but also a beacon of excellence in the legal education landscape. Let us all extend a warm welcome to Advocate Sudhar Pandey as he shares his insights and experience with us today. We heartily welcome you, sir.
Thank you so much for the lovely introduction, ma'am. So today we are going to start our discussion, and this is the first class of your workshop. So today we are going to focus on two major areas, that is drafting of legal notice, how to draft the reply of a legal notice, and how to draft a plaint under C, right? So before I start my in detail discussion, all of you are allowed to raise your questions. You can put up your questions in the comment section, in the chat section, or you can ask it by unmuting yourself. And now today we are going to discuss the basic formation of legal drafting. Since it's your first class, so firstly we are going to understand what is the major idea of legal drafting, how you should start drafting a legal notice. Like we know, if there is a case of check bounce under section 138 of a negotiable instrument act, if you want to draft a legal notice for breach of contract under Indian Contract Act or under Transfer of Property Act, or any kind of maintenance order a notice under section 125 of CRPC, or any other law for the time being in force, the basic ingredient of all of these remains the same. So what you have to do whenever you are drafting a legal notice, you have to start with the formal writing communication. And before we start into the detailed discussion of legal notice, firstly, let's understand what is the need of serving a legal notice. It is an intimation given to the opposite party that very soon we are going to start with the legal proceeding against you if you will not resolve our issue, or if you will not provide us the adequate remedy as mentioned in the notice. So it is an intimation. So whenever we start a legal proceeding, it should always start with the drafting of legal notice. Remember one thing, if you are a registered advocate, then only you can serve a legal notice on your letterhead. So to serve a legal notice, you should be registered under the Bar Council of the state or the Bar Council of India. I hope that thing is clear to all of you. Now, let's start today's discussion. Basically, a legal notice is a formal communication that notifies the recipient an intention to initiate a legal proceed unless the grievances is resolved. So, whenever I am filing a legal notice to someone, I am giving him an intimation that these are the grievances, these are the redressals I am seeking against you. If you will not provide me that, I shall move ahead with the legal proceeding. So whenever you are drafting a legal notice, these are the key elements. Firstly, it should be having the header and date. The header should mention like in context of breach of contract, right? Then you have to mention the date, like 11th of January 2025. Then you have to mention recipient's name, then address and the designation if applicable. Right? So sometimes what happens, suppose let's assume that you want to serve a legal notice to the state government or to the government of India. Then you cannot serve the notice directly to the state government or the government of India. If you want to serve a notice under section 80 of CPC, right? Then you cannot serve the notice directly to the government. So what you have to do, you have to find the responsible person who has been designated under the particular department of the government to respond on behalf of the government, either state or central government. So if that designation is applicable, you have to mention that, and you have to mention like recipient name. For example, I am just keeping the name hypothetically, Mr. Amol, right? Then the complete residence or the office address of Mr. Amol. Then if he's serving as a like for example, if you want to serve a notice to the central government, right? Then you have to serve it by addressing the Solicitor General of India, right? Or as the case may be, right? So you have to mention that. After that, you will mention the date of serving the notice. Then you will deliver the subject line. The subject line will be, let's assume I want to serve a notice to someone for a maintenance order under section 125 of TRPC or under section 138 of Negotiable Instrument Act, whatever. Then a concise, clear subject that summarizes the issue. Then you have to, here you have to mention all the concise issue, like you have to mention legal notice for breach of contract, for breach of uh, for transfer of, for specific performance of a contract under Specific Relief Act 1963, or if you want to serve a notice for any other purpose, you have to mention that, right? Or reclaiming any trespassed property, or you want to stop someone from creating nuisance, you want to serve an order of injunction, right? So you have to mention that. Then you will start with the introduction. Introduction is the prima facie statement that why this issue has arose. Then once you have discussed that, then you have to state the sender's identity and their relationship to the recipient. So here what you have to do, you have to mention that I, on behalf of my client Mr. ABC, he has empowered me to serve a notice on my client's behalf. So here you will mention that I am serving this notice to you on behalf of my client ABC. I am his legal representative. right? Or if you are an employer of a company and you want to serve the notice on behalf of any of your employee, or you have entered into a partnership firm, you want to serve a notice on behalf of any of your partner, then you have to mention that by what authority you are going to serve that notice. You have to mention that. Once you did that, you have to mention the advocate's detail if the sender is a lawyer. So let's assume I am a lawyer. So I'll mention it. I, Mr. Sudhar Pandey, Advocate Sudhar Pandey, registration ID number MPHC XYZ. Then, on behalf of my client, Mr. Um, Anmol, I want to serve this legal notice to you, right? Then you have to mention the statements of fact that on XYZ date, like on 5th of March 2024, my client, Mr. Anmol, entered into a contract with you for the supply of 100 kg of cotton bags, which was promised by you that you will deliver those bags. That is a completely hypothetical situation. It will vary from fact to fact, right? So then you will mention that you have committed to my client that you will provide him 100 kg of cotton bags on or before 10th of October 2022. After continuous reminder from my clients and after the passing of 10th of October 2024, my client has made the complete payment and he has sent you constant reminders for the delivery of those cotton bags. But you have failed in the delivery of those cotton bags. Thus, I have got the legal right to claim the amount which I have deposited as a security deposit or as an advance money, plus the compensation and the loss for the inconvenience I have suffered, plus all the legal costs, right? Then, after this, you will clearly outline the events of fact leading to the grievance, as I told you earlier. Then, you will mention the dates, agreements, promises, or any breaches. And if you are having any or physical copy of agreement, right? You can attach that in form of an annexure, right? Once you did all of this, then you will mention the next thing, and that is going to be the legal basis on which you are filing the suit. So here you are going to mention that as per section 39 of Indian Contract Act, anticipatory breach of contract, right? Or as per section 125 of CRPC, or as per section 138 of Negotiable Instrument Act in case of dishonor of check, or as per section 37, 38, 39 of Specific Relief Act in case of injunction, whatever the case, right? You will mention those legal bases. Then you will mention some of the relevant case laws of similar situation, right? So let's assume that suppose I want to file a case of breach of contract. So, and that contract I have entered into, okay, was with a minor. So I can mention the case laws like Mohari B versus Dharmodas. Suppose I want to enter into, I want to file a lawsuit for injunction. Then I can mention the case of Mareba Minerva Mills versus Chandan Lal Mehta, and so on, whatever the situation, right? Then you will mention the specific clauses of the agreement that supports your claim. So whatever agreement you have annexed in that agreement, there will be mentioned this is how this contract has to be performed and this is how you have breached the contract. Then you will claim your relief which you are demanding. Like you can mention the lump sum amount of money which you want to claim, for example rupees 5 lakh plus the cost of suit or decree, legal expense, right? Then state the action sought. So now you will give the intimation to the next party that if you will not make the payment on or before like 10th of February 2025, then it shall empower me to file a legal suit in the court law in the jurisdiction of. Let's assume this contract has been entered into between Anmol and Mr. A in Nagpur, right? Or as per the terms of the agreement, the jurisdiction of Nagpur court shall lie over this breach of agreement. Then in that case, you will mention that I am giving you the timeline 15 days, 30 days, whatever is there. Okay? If you will not make the payment, I shall proceed ahead with the breach of contract case or dishonor of check case, whatever. Right? Then you have mentioned the consequences of non-compliance, such as initiation of legal action in the court of law. Finally, you will put your signature at the end of the document. Here the signature will be signature of advocate along with the ID number or identification number of that particular advocate. Then once you did all of this, now let's see a sample format, right? If you want to create a legal notice, what is going to be the sample format of that? Mentioning sender's address. Here I'll fill each and everything. Sample format for a legal notice. Mr. Anmol Sinha, son of Mr. Rajkumar Sinha. Right? Someone asked something. Is signature of, yes, signature, attendance. Whose attendance is mandatory? I don't know. Signature of client is required. Right? Then date 11th January 2025. 2, right? Like this is the sender's name and address, E96 phase 2, Eldico County, Gwalior, Madhya Pradesh. Right? To Mr. Chetan Khanna, son of Mr. Ramlal Khanna. Address E32 Karol Bagh, Delhi. Subject legal notice for specific grievance. Here I will mention breach of contract. Under the instruction from my client, mentioning the client name Anmol Sinha. Here I serve you this legal notice as follows. Here you will narrate the whole facts in paragraph format. Paragraph 1, 2, 3, 4, 5. Whatever was the whole story. How you have got this cause of action. Like let's assume that this is the case of maintenance order. Then you have to mention that my client Mr. ABC married with you on XYZ date. You were living together till XYZ date. Then some differences started arising between you and my client. So you decided to leave my client on XYZ date. Since that date till today, my client is living all alone, along with the custody of children, and she hasn't received anything in form of maintenance. And now she wants to file a divorce petition along with maintenance. Right? So if you will not reply to this notice, it shall be considered that you are keen to go for a legal proceeding against you want to go for a legal proceeding of maintenance case. So, couple of questions, if you don't mind. Yes, what is the jurisprudence purpose of a notice? Sometimes I see it is a part of a special statute, and sometimes it is an unofficial norm. How to decide which is which? So now let me. I don't know your name, Mr. S. Phone. What I shall assume, Sarjeet. Okay, so Sarjeet, I'll tell you. How does it work? There are two ways of serving the notice, legal notice. One is general notice, general legal notice, which can be drafted by you or by your advocate. But whenever you are serving the notice under any specific statute, mentioning that I'm serving you this particular notice in case of breach of contract under section 39 of Indian Contract Act, then it is the official precedented legal statute, legal notice, and that has to be served only by an advocate, right? And it should be drafted appropriately. Does it not like read a memo with all these details disclosed? Does it not put one at a disadvantage when the court is when a suit is argued in the court? Second question is not thoroughly clear to me. Please try to rewrite it in a more phrased manner. Then I'll be able to address it. Then once you did that, then you will mention that you will specify the basis of your legal claim. It shall majorly include two things. First, some relevant provisions. Second, some relevant case laws. As a lawyer, this is the work of your research. Sir, can only an advocate send a legal notice or anyone can send it? Is it valid if not sent by a non-legal? Aditya Thakur. Aditya Thakur, here you have to see there are two things. If you want to serve the legal notice on behalf of third person and you are not an advocate, you cannot serve a legal notice on behalf of a third person. If again, you have to understand there are multiple questions comes here. If you are having some kind of relation, like that person is your employee, that person is partner in your firm, then you can serve the legal notice, and that legal notice shall not be admissible in the court of law. You cannot say it was a legal notice. Legal notice can be served either by an advocate, or I can serve legal notice for myself if I don't want to hire an advocate, or I myself is a registered practitioner or registered advocate. Right? I hope this thing is clear. Now, then you will demand the specific relief or resolution. Then you will mention what you are exactly seeking. What is the remedy you are seeking? Why you have served this legal notice? Provide me this much amount monthly, provide me this lump sum amount. Like in case of dishonor of check, like I have given you the check of rupees 10 lakh, kindly make the payment on or before this date along with interest. If you will not do it, I shall assume that if you will not do it, I shall assume that it is a breach of it shall be considered dishonor of check. So I hope this thing is clear to all of you. Now proceeding next, let's discuss in detail in a more detailed manner. At last, you have to mention that hereby instructed to comply with the above mentioned demands within mentioning number of days 10, 15, 20, failing to which will lead to initiation of legal proceeding against you. Right? Then, at last, you're sincerely mentioning lawyer's name and contact detail, and at the end, at the footer, if you want, you can provide the detail of and sign of client. Right? Now, sir, if I correctly understood that one who is not an advocate can serve notice only for and by himself, request you to clarify. Yes, exactly, Amarpreet. Now, heading next, how to draft a reply of a legal notice. So whenever you are drafting the reply of a legal notice, what all things should be kept into consideration. So whenever you are drafting a reply of legal notice, it is equally important as drafting of legal notice. So whenever, let's assume that someone serves me a legal notice and I realize that no, this is not the correct fact he has mentioned. He has misled some fact, or I have agreed upon the terms and conditions which that person has mentioned. Then I can give my reply. In the reply, what I have to do, I have to mention the key elements. I have to mention the acknowledgement of receipt. Acknowledgement of receipt means that these are the facts I am agreeing upon. Right? Hello. Can a legal notice be served by a non-legal for a third person if that person gives the person who is serving legal notice power of attorney? No, it cannot. There is nothing like power of attorney concept in serving the legal notice, right? So, Ram, if you want, you can, Ram Kumar, you can write your question in the chat section. Heading, when we are talking about mentioning the acknowledgement of receipt. So whenever you are mentioning the acknowledgement of receipt, you are agreeing with certain facts. Like you have agreed, yes, there was a contract between you and me. On XYZ date, we have entered into a contract. Then you have mentioned that, yes, I have agreed to supply you 100 kg of cotton bags. Third point, you are agreeing that, yes, I have promised that I will deliver it on or before 10th of October 2024. Begin the fourth point of the mentioning of notice, which you deny. Yeah, I have already served you the cotton bags. You are lying. So here you have to mention it specifically. If few points I have acknowledged, few points where we are agreeing on the same page. But there are certain things which we do not agree. Like in case of serving a notice of maintenance, you have to agree that we have got married, we are living separate from XYZ date, but I am providing you the maintenance from this date, right? As per the court order or as per the convenience of the parties, whatever the case is. Okay? Then you have to acknowledge the receipt of legal notice, that I have got your legal notice. I am acknowledging it. These are the facts I am acknowledging. Then you have to submit your denial or admission of claims. These are the claims I am denying, or you may admit all of the claims, right? This admission and denial is done under Bharatiya Sakshya Adhiniyam, BSA. And remember one thing, that whenever you are denying or admitting a fact, this can be used as an evidence against you in the court of law. So whenever you are giving reply, you have to give it wisely in consultation with a legal practitioner. Okay? Then you can accept or refute the claims with clear reasoning and whatever evidence you are having. Then highlight if you find any kind of discrepancy in regard to legal notice. You can also mention that this legal notice is futile. Why? Because this legal notice has XYZ problems. Like it has shown that the case will be filed in the jurisdiction of Nagpur court, but this case should be addressed by Delhi court or whatever the case is, right? Then you can mention your clarifications or counter claims. That is very much important. Here you can go for set off or counterclaim. Remember that this set off or counterclaim shall not be dealt by order 8 rule 6 6A to 6G of CPC. इनसे ये govern नहीं होगा, because it is not the written statement. The next person hasn't served you plaint yet. That was just a simple legal notice. So in a simple legal notice, whenever you are giving your counter claims, you can mention, yes, I am liable to pay you 10 lakh rupees, but you are also liable to pay me 15 lakh rupees, which you have taken from me on XYZ date, or on the basis of service of ABC contract, whatever the case is. Then if you are having any kind of explanation or justification of your action as a government official, you can justify that. Then you will also mention your grievances against the sender, right? You can mention this thing to the sender that Mr. A, if you will not, Mr. Anmol, if you will not pay me my 15 lakh rupees, I shall file a legal proceeding against you now. So this is giving you additional power to go for a legal proceeding against that sender of notice, right? Now, then if you want, you can also go for a amicable solution. If you want, you can also go for an amicable solution. Sorry to disturb you. There is a minor disturbance in voice. Zainab, is there anyone else feeling that disturbance? Please just let me know in the comment section so that I can rectify it. No, no. So I think there's some internet connectivity problem from your end here. Please check it. Now, you will provide any amicable solution. Like sometimes what happens that whenever you are serving notice, reply, you can mention that, okay, I address whatever you are stating and let's make out of the court settlement. I request you not to go for a legal proceeding against me. I accept and acknowledge whatever you are stating, and I am ready to pay you ABC amount. Right? Or if you want to go for any negotiation out of the court, remember, abhi court ka role start nahi hua hai. The court process hasn't begun yet. So if you want to go for a negotiation, you can also mention the date and place of negotiation. Right? Then proceeding next. Yes, someone asked, sir, what happens if someone not reply? If someone doesn't reply to the legal notice, Abhishek, we are empowered to file a legal suit against that person. After the passing of the time period which you have prescribed in the legal notice, if the next person doesn't reply, you can go for a legal proceeding against that individual. Sir, if we open all the points here, would it not prove harmful during trial? No, it will not be harmful, because let me tell you, Nitesh, whenever you are going to serve your plaint, in the plaint you also have to mention the cause of action and everything, and then only the next person will file the written statement. In Indian judicial system, we believe in the process of audi alteram partem. That means let's hear both the parties and no one should be condemned unheard. So whenever you want to file a legal suit against another person, you have to mention on which grounds you are filing the legal suit. Otherwise, it will be of no use for the next party. BA, sir, can we mention in response wherever we think it's appropriate submission without prejudice in legal notice, that will that be held against the respondent of legal notice? BA, your question is not thoroughly clear to me. Please rephrase it if possible. That will be so nice of you. Now, if you are having any kind of specific rights under any specific law, and if you feel that this legal notice should not be served to you because the limitation period is over, as per Limitation Act 1963, the period of service of legal notice was over, or the period of filing the legal proceeding was over. So you can mention those rights if you are having that, right? That's called the prescribed rights, which you have got under Section 26-27 of Limitation Act. Then reserve the rights to take further legal action or defend oneself in the court. You can also mention that if you will not make the payment now, I shall file a legal suit against you, right? And you can file the case against that particular person. Then you have to put your signature signed by the recipient or their legal representative. I hope this thing is clear to all of you. Now let's see, sir. That was my question to sir. Notice with all the details is as good as plain. What not to write in it to have some advantage when the suit is actually argued. Now, here what you can do, you can briefly mention that you are going to claim your relief under Indian Contract Act, Specific Relief Act, Sales of Goods Act, Transfer of Property Act. You need not to mention the provision numbers, right? And you can state that I am going to refer XYZ case law, right? So what is amicable solution? Amicable solution is like mutual understanding solution out of the court, like a sort of negotiation done between the parties. Reservation of right, Srinidhi. Reservation of right exactly means, if I'll explain you in one line, reservation of right is a very simple thing. That you are not allowed to serve a legal notice to me. I am having prescribed right. Under limitation law, the period of limitation is over for this particular subject matter. Let's assume it is a case relating to a movable property. There the limitation period is of 3 years. And next person is serving you the notice after expiration of 3 years. Then the limitation period is over. Sir, in what situation we should not sign legal notice? It is not possible. In most of the cases, you have to serve legal notice, right? Ram Kumar, If you want to file a writ petition, then you don't have to serve the legal notice under High Court or Supreme Court under Article 32 or 226 of Constitution of India. Then you don't have to serve legal notice. Otherwise, it requires to serve a legal notice. Or you want to file a criminal case against an individual, then you just have to go for an FIR. You don't have to serve the legal notice. But for most of the civil suits, the initiation stage is serving of a legal notice. So it is called paralegal process. It is called paralegal, means partially legal, quasi-legal process, right? It is actually not legal, but before legal process initiate, this step has to be followed, right? Now, heading towards how you have to mention the sample format of your reply. Recipient address. If the matter is going to go to court, is it better not to reply to notice so that our facts are not known to the other side? Khalid, you have to mention it. Otherwise, let me tell you, if you will read Order 7, Rule 11 of CPC, your plaint can be rejected at later stage if it is not showing cause of action. So you have to mention it. You cannot hide, right? Sir, what would be the alternative in case where the right gets expired? Aditya Upadhyay. In that case, technically you are not having any right until and unless that person makes another agreement with you to pay a time barred debt. As per Indian Contract Act, if that person agrees to pay you a time barred debt after expiration of limitation period, then the new limitation period will start. Nitish Kumar, sir, no reply is not mandatory. If you don't want to reply, if you have made up your mind that you want to go for a legal proceeding, then you don't have to reply for it. Then the next person will file a lawsuit, and then once he files the lawsuit, he will give you the plaint. Someone will be served to you. Along with someone, you will get the plaint, and then you can directly file your written statement. Right? Now, date to sender's name. Sender's name will be obviously the person who has served you the notice. Sender's like address. Subject reply to the notice dated. You will mention the date on which the notice has been served to you, which has been mentioned on the notice. That date you have to mention. Then you will mention it. Dear, mentioning sender's name. I acknowledge receipt of your legal notice dated on XYZ date. Yes, you can. Sai Pratna, you can initiate legal proceeding without sending the reply notice. That is not mandatory to mention the reply. After reviewing its contents, I respond as follows. Either you will refute or you will admit the claim mentioned in each number of paragraphs. So here you have to, whenever you are giving reply to the notice, it should be evasive denial. As per Order 7, Rule 2 and Rule 3, you have to counter each and every point. At this point, I am agreeing. Para 1, I am agreeing. Para 2, I am agreeing. Para 3, disagreeing. Para 4, agreeing. Para 5, agreeing. Para 6 and 7, disagreeing. So you have to mention it specifically. Sir, is it mandatory to serve legal notice before proceeding legally? If yes, in what matters and how do we decide? Let me tell you, in all the civil cases, you have to serve the legal notice. But in the cases of criminal cases or writ petition, you don't have to serve the legal notice. Yes, you can ask for the compensation or inconvenience or delay that has been caused in the legal notice itself. Right? You can ask for that. Then you will mention your defense and cite evidence on which you are relying in this particular case. You will mention all your defenses and the defenses on which you are relying in this particular legal suit. Then I reserve all rights to take appropriate legal action in this regard. Your mentioning your name, recipient name, or the lawyer's name. If you have got the lawyer's and recipient's name, both you have to mention both. If you have got either one of them, you will mention that to the next party, right? The person who has served notice to you. Now, heading next. Let's understand the sample draft of a plaint. How to draft a plaint. For a legal process, how to draft a plaint. Is it necessary to serve a notice if already one case is going on in court and another case is or to file against? Yes, you have to serve another legal notice. If it is, now you have to see various things. If on the same subject matter you want to file a suit, it will hit by section 10 of CPC, that is res sub judice, right? So on the same subject matter you cannot file a case, so there is no point of serving a legal notice. But if you want to file another fresh suit on different cause of action against the same party, then you have to serve the legal notice. It's simple. Let's understand the sample draft of plaint. So the plaint is now remember one thing, plaint is something now you have entered into the legal process. Now you don't have any option to step down, right? Now there is no case of settlement or anything. Now you will go for the legal proceeding, right? And whenever you are drafting your plaint, you will mention in the court of jurisdictional court name, in the court of civil judge, junior division, Madurai, right? At place Madurai. Number which shall be provided to you by the court, right? Suit number, whatever the suit number is, XYZ of 2025. Then plaintiff's name. Since you are filing the plaint, so you will become the plaintiff. And the person who is going to defend that plaint will become the defendant. That's how we have got the word plaintiff and defendant in legal proceeding. So mentioning the plaintiff's name, I'll keep it Mr. Sumit Kumar, son of Mr. Vinay Kumar, resident of whatever the residence is there, occupation, whatsoever occupation is there, aged about, यहाँ पे एक term लिखा जाता है, aged about 43 years, right? 20 years. Is civil suit number, no, it is not the serial number of the advocate, right? It is not the serial number of the advocate. In partition suit needs to send the notice prior to filing partition suit regarding properties. Yes, file. In partition suit also you have to serve the legal notice. Then you will mention here plaint and mentioning the defendant, Mr. ABC, son of Mr. XYZ, address ABC, whatever is address, occupation, age, and defendant. Once you mention all of these things, then we will head towards next. Plaint. The plaintiff respectfully submits under, and here you have to mention, like there are multiple parties, or there are one party, two party, three party, whatever number of parties are there, you have to mention all the parties as a plaintiff number one, plaintiff two, plaintiff three, plaintiff four. And even if you are filing a representative suit, then also you have to mention all the plaintiff's name, and you have to mention it like plaintiff number one is the representative of all other plaintiffs. So let me tell you how does it work. Let's assume that a company has done fraud with 100 people. These 100 people want to claim compensation against that company. Now, out of these 100 people, one person will regularly attend the court on behalf of other 99. So it will be mentioned, you would have seen in numerous of cases, like Nagendra Kumar Singh and others versus ABC company and others. So here others means multiple plaintiffs or defendants are there. Then you have to mention parties to the suit. Here you have to mention the defendant is, name of the defendant, residing and engaged in occupation. Then the defendant name, residing, engagement, occupation. And this is the sample format available under CPC. Remember one thing, for this we have to follow the procedure of CPC. There is a schedule under CPC under which the format is given for each and every plate, right? So I'll suggest you people, if you people want to draft any kind of plate, you can find it at the back of CPC Bear Act, like in money overpaid, money lent. For each and every case, there is a different kind of format of drafting the plate. Then you will mention the jurisdiction. This honorable court has jurisdiction to try the present suit as the cause of action arose between its jurisdiction. Now you have to, whenever you are going to file a lawsuit in a particular court, you have to convince the court that this court has the power, jurisdiction to hear this particular matter. Now there are two types of jurisdiction which comes into the picture. Technically three, but majorly we have to categorize it into two subheads: territorial jurisdiction and subject matter or pecuniary jurisdiction. Territorial jurisdiction is why I have filed this case in the Court of Civil Judge Junior Division in Madurai. Why not in any other court? So you have to mention that the contract has took place. The place where the contract has been made is Madurai. So Madurai court has jurisdiction. Now the next question is, why you have filed this case in Madurai Civil Judge Junior Division? Why not in Senior Division? Why not in District Judge Court? So you have to mention that the amount, the value of contract compensation which I am seeking is 3 lakh. So it is the pecuniary jurisdiction. Coming to next subject matter jurisdiction is, suppose you want to go for partition. Then as per section 17, 18, 19 of CPC, in various cases, in the case of immovable property, where the immovable property is situated, there the case can be filed. In the cases of wrong done by a defendant, where the defendant ordinarily reside or work for gain, at those places case can be filed. So it varies, right? Now, sir, which section or order of CPC tells about? It is provided in the schedule. At the back of CPC, you will find the schedules. Like once you are done with all the sections and orders, at the end you will find schedule. Schedule 1, 2, 3. There you will find the formats. Right. Now, proceeding next, you will show the cause of action. Right. So, in the cause of action, you have to mention the cause of action arose on XYZ date. Now, why you are mentioning cause of action date? To show to the court that this suit is not barred by limitation law. Limitation Act 1963 under it is not barred. That's why you have to mention the specific date on which you have got the cause of action. And when the defendant describing the event leading to grievances, what defendant did due to which you have got your cause of action, right? Sir, can you explain once again what is subject matter and how it is different from territorial and pecuniary jurisdiction? We may not. Now, let me tell you, subject matter jurisdiction is regarding the property. Pecuniary jurisdiction is regarding the money. And territorial jurisdiction is regarding the territory. Right? Have you got these three things? Now, you have to mention facts of the case. Then you will start mentioning on a specific date, plaintiff entered into an agreement with defendant of nature of the agreement, whatever sale, service, lease, license, whatever is there. As per the terms of agreement, the plaintiff mentioning the details that the plaintiff has complied with the agreement. Like I have entered into a contract with Mr. ABC to supply him 100 bales of jute every month. I continue supplying for next 7 months. But when I haven't received any kind of payment from the defendant, I stopped making the further kind of payment. Hello, sir. If a private limited company is incorporated in one state and company's corporate office, wherever is the corporate office, there you can file the lawsuit, Neha. Right? And if that company has done breach of contract, then in corporate office, and if the contract has been made in the case with, at the place where the company is working, then at that place. And in third case, if the company has registered office in one area and personally works for gain in another area, and company has done some sort of fraud with you, then you can file the suit at both the places. In this case, one party can be that branch office also, right? Yes, one party can be that branch office as well. Now, then you will mention, however, the defendant describing the breach of agreement or wrongful act done by that particular defendant. Then you will mention that the defendant has failed to specify the breach or wrongful act, right? Sir, can a legal notice be challenged on the ground of any deficiencies in the legal notice, like section wrongly mentioned or technical deficiencies? No, Praful, it cannot. But if there is any kind of fallacy or any kind of deficiency in plaint, it can be challenged, right? Which has caused loss and inconvenience to the plaintiff, despite repeated reminders the defendant has not remedied the breach, right? Then you will mention the legal basis on which you are filing the lawsuit. As per section 62, there was the alteration of contract. As per section 39 of Indian Contract Act, there was a breach of anticipatory breach of contract, or whatever the case, right? You will mention it. Then you will mention the relief which you are seeking. Now here is a list of relief. Out of this, you can seek one or all of these reliefs, right? Depending on the nature of suit. First one, you will mention a decree directing the defendant. This decree can be for the specific performance of the contract. Like, I don't want any compensation. I want you, because you have promised you will do this thing, please do it. But remember this thing, that this specific relief should be dealt as per section 10, 14 and 16 of Specific Relief Act. So if any of the condition of section 10, 14 or 16 has hit, then you cannot seek specific performance of contract. Okay? Or else you can ask for your compensation amount. And whatever the amount is, with interest rate of 6% per annum. Right? And in the cases of commercial contract, it may go up to 18% per annum. Then the next remedy you will seek is cost of suit. Now, what is cost of suit? Just because of you did a breach of contract, I have been obliged to file a legal suit against you. I was not keen to file a legal suit against you, but you have left me with no option apart from filing a legal suit against you. So now I want you to pay the cost of suit. Then any other relief as the honorable court deems fit. This you mentions to give the scope to the judges, like if they want to give you any exemplary damage. Exemplary damages, then they can offer you that as well. What is the cost of suit? Khalid Desai, cost of suit shall include various things. First, the cost of attorney, the court fees which you have paid, the stamp duty which you have paid, the paperwork cost which has arisen, right? Got it? Now, you will mention valuation. Valuation is valuation of that particular contract, right? The plaintiff values the suit worth rupees 2 crore for the purpose of mentioning the jurisdiction, that why I have filed this case in the court of district judge. Why I haven't filed it in the case of civil judge, junior division, senior division? Because they cannot deal with the cases more than 1 crore. So I was obliged to file the case in district judge court, right? And court fees has duly paid. Okay. Once you pay the court fees, then you will get the case number. Sir, what is the cause of action and how it is different from fact? Some mobile number. Okay, so let me tell you, cause of facts. Let me tell you how does that work. Facts is I married with Mrs. A. That is a fact. We lived together for 3 years. This is a fact. Uh, we have given birth to 2 babies together. This is a fact. Out of some differences which started arising, me and my wife started to living separate. Now this has given cause of action for my wife to file a legal suit against me, right? No, it cannot go beyond 18%. Nitish, I hope this thing is clear. Cause of action is the main issue, main dispute. Why you were obliged to come to the court. The fact is the collection of all the facts. Right? Now, prayer. In the prayer, you will mention, in the light of above mentioned fact, the plaintiff prays this honorable court to kindly please to grant a decree against the defendant for rupees 2 crore along with the interest rate 6% from the date on which you have got cause of action. From the date on which you have got cause of action, you can mention that date, and from that date, you will get the market interest rate, that is 6% per annum, right? And why the interest is paid? Try and understand. The law simply assumes that if he would not have done that breach of contract, you would have got that money, you would have invested it somewhere in the market, and that money would have increased. So that's how you get the interest for that particular amount of money. Then next you can mention is award the cost of suit to the plaintiff. The plaintiff was obliged to file the suit because of the failure on behalf of defendant, and that's how the plaintiff can claim the money which he wants to claim as a cost of suit. Grant such other relief as this honorable court deems fit, looking into the circumstances of the case. No, it is not mandatory to claim interest. Let me tell you, Meenakshi, but people do claim it, right? It is not mandatory. If you will not mention it in your plaint, remember one thing: you cannot claim it at later stage. The court shall not allow you to alter the plaint so easily, right? Until and unless there is no addition of new fact, the court shall not allow you to alter your plaint. And then at later stage, if you want to claim interest, you can't, right? Then you will mention the verification. Verification as the plaintiff. You will verify that I, plaintiff, above mentioned fact, do hereby verify that the contents of paragraph 128 are true and best to my knowledge. Now remember one thing. Here, whenever you are verifying a plaint, it means in the legal process you are claiming that whatever mentioned is correct. And now you cannot refute from your statement. Sir, in case of declaration of legal heirs, the concept of legal notice exists. Yes, in the cases of declaration of legal heirs, the concept of legal notice exists, but usually it goes with the public notice as per Hindu Adoption and Maintenance Act. The last point you have not explained. Which one I haven't explained here? Now, sir, any specific provision? Yes, yes, there are specific provision. I think section 35 and order I cannot recall as of now. Previous last. Okay, let me see to it what I haven't discussed. Just a second. I think I have discussed grant such other further reliefs as the honorable court deems fit in the circumstances of the case. The court can grant me any other relief if the court deems it fit and suitable for me. Right? Now, let's understand. You have to mention as a plaintiff, you have to sign it. Name of the plaintiff, advocate's name, advocate's address, signature of address, signature and advocate's bar enrollment number. Right? Procedure of filing the plaint. So to file a plaint, there we can say there are 3 stages. Pre-filing requirement क्या होती है? During filing requirement क्या होती है? And post-filing requirement. So we can categorize it in 3 parts. Pre-filing requirement, during filing requirement, and post filing requirement. So let's start discussing all of these one by one. Whenever you are filing a plaint, pre-filing requirements are, whenever you are drafting the plaint, you have to follow Order 7 Rule 1 of CPC, which means you have to ensure these things under Order 7 Rule 1, that is name and description and address of plaintiff and defendant both. That has to be mentioned in a plaint, otherwise the plaint shall be rejected. You have to state the cause of action, why you were obliged to file the lawsuit. Jurisdiction of the court you have to mention, relief which you want to claim you have to mention, verification clause, and additional supporting document. And here one more thing is there. You have to file the plaint in duplicate. If you haven't filed the plaint in duplicate, it might subject to rejection. Why it is filed in duplicate? Because the original copy remained with the court. The duplicate copy is given to the respondent along with the summons. So you have to file the plaint in duplicate, and if there are more number of defendants, the number of defendants are, let's assume 10, then you have to file 11 copies. One copy shall remain in the court and remaining 10 copies shall be served to each defendant individually, right? Attach all the supporting documents relevant to your claim, and receipts, contracts, correspondence, whatever evidence you are having, you have to attach it in form of an annexure. Then you have to prepare the list of documents that has to be filed with plaint. So what all documents you have to file whenever you are filing a plaint? What all documents? This you can say a checklist for you, right? Firstly, the court fees receipt. The court fees receipt, which shows that you have paid the prescribed court fees. No, Fahim Firdaus, you have to submit the original documents, right? Or photocopies. But remember one thing, whenever the court want you to present the original copies, you have to present it. So these Fahim, this complete thing is dealt by Bharatiya Saksh Adhiniyam. If it is a public document, you can submit the certified copy of that document, right? If it is a private document in your capacity, you can submit that. If it is a private document and it is in the possession of another party, then you have to mention it. I am submitting the duplicate because the original copy is with another party, and the another party may or may not accept the fact that that party has the possession of that document. And if other party denies that I don't have possession of that document, then that party for his purpose also cannot use it. A public document example like registry, land registry, that is a public document. The original copy remains in the office of registrar of land revenue. They gives you the certified copy, right? Now you have to pay the appropriate court fees as per Court Fees Act 1870. You have to pay the prescribed court fees. Then you have to attach the receipt of payment of court fees. Then you have to ensure that whenever you are filing a lawsuit, you have filed it in the correct court. The court has jurisdiction to deal with this case. So here you have to check all three things: subject matter jurisdiction, territorial jurisdiction, and pecuniary jurisdiction, right? The court has authority to hear the case, subject matter jurisdiction, territorial jurisdiction, that this area court has, specific area court has the power to hear the case, and the value of the claim falls within the jurisdiction of the court. You have to mention all these three things, and you have to ensure that all these three things should be followed. Then during filing of plaint, what you have to ensure: submission of filing section, file the plaint while filing section in the appropriate court. The jurisdiction, Khalid, you can read CPC section 6 deals with pecuniary jurisdiction. Section 16, 17, 18, 19 deals with territorial jurisdiction, right? then the case shall be rejected. Remember, then in that case, Order 7, Rule 10 shall apply. Advocate Meenakshi, Order 7, Rule 10 shall apply, and the court shall return the plaint for presentation in the proper court. If any of the jurisdiction the court doesn't have, then the court shall return the plaint for presentation in the proper court. Right? Now, whenever you are submitting the plaint, along with submitting the plaint, you have to provide supporting document, list of document, and proof of court fees payment. Stamping and scrutiny you have to do, right? Then the court staff verifies the plaint for compliance with the procedural requirement. If you have followed all of these things, your suit shall be admitted. Then, if in case of any kind of deficiency like improper formatting, missing documents, it must be rectified by the plaintiff as per the direction given by the court staff. And if you do not do the same, it might lead to rejection of suit. It might lead to rejection of plaint. The court has given you the time. Usually, the court prescribes the time period of 7 days to rectify the plaint. But if you don't do that within that prescribed period, then it will lead to rejection of plaint. Then registration of suit. Then upon compliance, the court registrar shall assign you the registration number and case number. Then the court shall issue the summon to the defendant. And when the court shall serve the defendant, the court shall serve the summon to the defendant. Along with that summon, what is summon? Summon is the legal notice to the defendant that Mr. ABC has filed a case against you on XYZ date. You have to come to the court, right? Or you have to file your written statement within 30 days of receiving of summon. Along with summon, there shall be attachment of your plaint, right? It is checked by the court itself, Advocate Mubashir. It is checked by the court itself, then only they will provide you the prescribed case number. The summon is served through registered post, court bailiff, and other prescribed mode as prescribed by the High Court of that state. It can be served by the courier services prescribed by the High Court of the state. Now, post filing procedure. Once you are done with the filing of your plaint, then we will head towards written statement. Filing of written statement shall be done by the defendant. Okay? The defendant has to file the written statement within 30 days of receiving of plaint. And in exceptional cases, with the prior permission of court, it might extend to 90 days. Right? After receiving the written statement, the court frames the issue and basis on which the suit begins. Right? So this is now coming to the checklist which you have to follow while filing the plaint. You have to ensure that your plaint should have proper heading and jurisdiction of the court. In the Court of Civil Judge Junior Division, Chennai. Name, address, and description of plaintiff and defendant, cause of action and relief sought, signature of the plaintiff and advocate's ID number, verification clause, supporting documents, original document or certified copies, whatever the case is, list of document, proof of the court fees, additional document, wakalatnama. If your case is like you have filed a case through your legal representative, then the lawyer has to file a wakalatnama. That wakalatnama is a sort of verification or assurance to the court that this party has authorized this particular lawyer to defend the case or to plead the case. Yes, Kamlesh, the defendant can take certified copies. Yes, the PDF you will receive, Neha. Supporting documents means any kind of additional document, like I have made the payment. So I am having receipts of those payments, right? Or I have made the payment through courier. So I am having receipt of that courier. So these things can be mentioned, right? Now, coming to the legal provisions of CPC which are dealing with your plaint wala thing. So order 6, which defines pleading in general, deals with the essentials of plaint. Format of plaint is provided under order 7, right? Section 26 mandates that every suit shall be instituted by presenting the plaint. So no civil suit can be instituted without presenting the proper plaint. What, sir, can you please show the verification clause once? I'll show it. Supporting document is evidence. Yes, Afrin, supporting document is evidence. Now, determining the appropriate jurisdiction and calculating the court fees. How you can follow this process? Let's understand this process also. The jurisdiction refers to the authority of the court to hear and decide the case. Under CPC, the jurisdiction is categorized into 3 main types. Subject matter jurisdiction. This pertains to the nature of the case and whether a particular court has the authority to adjudicate this matter or not. For instance, certain courts are designated to handle specific kind of cases. Let's assume you want to file a case regarding like under Competition Act, then you have to file it in CCI, Competition Commission of India, right? Or CAT, Central Administrative Tribunal. You want to file a case of company law, then Company Law 2013, then you have to file it in like Company Law Tribunal, CLAT, right? So it is from case to case, it differs where you can file the case. I want to file a case for maintenance, then I have to file it in the court of like judicial magistrate of first class, JMFC, right? I want to file a case for breach of contract, then I can file it in the court of like civil judge junior division, senior division. So subject matter jurisdiction is which court is empowered to deal with this subject, right? Partition ka case, it will be dealt by civil court, like civil judge, junior division, senior division, or district judge. Then territorial jurisdiction. Okay? According to section 20 of CPC, a suit should be filed by the where the defendant resides or carries on the business or where the cause of action has arose. Right? Pecuniary jurisdiction. As per section 6, it involves the monetary value of the subject matter of jurisdiction. Different courts have limitation on maximum or minimum value of the case they can entertain. So each court has a prescribed limit of which amount cases they can deal with. So as per section 6 of CPC specifies the court have jurisdiction only over certain monetary value suits. Okay? If the value of your suit is lower or higher to that, then you cannot file a suit in that court. Right? Now, whenever you are going to determine the nature of the suit, you have to identify whether the case involves immovable property, contract, tort, or a specific relief, or whatever. Okay, as per it might affect or influence the jurisdiction. Location, determine where the cause of action arose or where the party resides or conducts the business. Valuation, accurately access the monetary value or the claim to ascertain the appropriate code. Now, calculating the court fees. The court fees should be calculated as per Court Fees Act 1870, right? Steps to calculate the court fees. The do certified copies means ones which have digital signature, which are electronically generated. Sai Prathna, no, exactly this is not the case. Certified copies means the document which you have got from a public authority. So what happens, like you want to get a registry. So from the office of registrar, you will get a duplicate copy, and each page of such copy shall be signed by the registrar. That shall be considered as a certified copy. If the suit involves both specific relief and removal property or movable property, then in that case, the case can be filed where the plaintiff or defendant ordinarily works for gain or reside or where the immovable property is situated. Right? Fine for those. Now, so to calculate court fees, what is the process? Firstly, assess the nature of the suit. Right? The court fees differs whether on the suit is for recovery of money, property, dispute, injunction, whatever. Then valuation of the suit, this determines the exact money value of the claim. For instance, in money suit, the court fees is typically a percentage of amount claimed. Like I want to like file a suit for recovery of rupees 20 lakh. Then I have to pay 2% as a court fee or 5% as a court fee, whatever the case is. Right? Now, next, refer to appropriate schedule. The Court Fees Act contains schedule that specifies the fees structure. For example, as per Court Fees Act 1870, you will find the cases where the case can be filed. Now, if there is any kind of state amendment which is affecting the fee structure, that also you have to take into consideration, right? While dealing with a particular kind of suit. Now, if you file the suit and you feels that your suit claim is exempted under Court Fees Act, or you are entitled to get the reduced court fees in any particular case, then you can mention those grounds and claim your exemption if you are having from court fees. And then at last you have to attach the payment of court fees proof, right? Sir, if any clause mentioned under the terms and condition in the dealership application form is violated, will it amount to breach of contract and monetary compensation can be claimed? Yes, Neha, monetary compensation can be claimed and it will amount to breach of contract. Right? Clear? Now, the platform is open for your questions. Dear moderator, if you are available, please allow the candidates to unmute themselves so that they can ask the questions.
Sir, of course, they can ask the questions, and thank you so much for the wonderful session. Participants, you may unmute yourself and ask to the speaker directly.
No, senior citizen doesn't fall in the exemption.
Sir,
Yes.
good evening, sir. Myself, Nitish. I have
Yes,
a doubt
Nitish.
here. Can I add something like a pre-suit interest to bring a matter within a pecuniary jurisdiction?
Yes, Nitish. Your
Sir,
voice.
yes, sir. Sir, my
Hmm.
question is like this. Can I add a pre-suit interest? Say the value of the suit is a interest.
Yep. You can add. Yes, you can add pre-suit interest.
Perfect. But will that not be used as a disadvantage to move the case from civil court to commercial court?
No. This will not act as a disadvantage to move from a civil court to commercial court, because let me tell you, whatever is your suit value, on that only you have to pay the prescribed court fees, right?
Whatever is
Understanding
on
my
the
point?
suit value, that is only the pecuniary jurisdiction.
Yep.
So it is not on
Right.
the interest value.
No, it is not on the interest value. It is only on that particular amount.
Perfect. And second thing, again, there is a cap on the interest even in the commercial courts, right, sir?
Yep, that is 18%.
That is 18%.
Yep.
Perfect, sir. Thanks a lot, sir. It was very useful.
Yes, anyone else?
Hello, sir.
Yeah,
Hello,
sir,
sir.
what is this cause of action jurisdiction then? Is it the same
What-
like subject cause of action jurisdiction, section 20? So is it same like subject matter jurisdiction or is it different?
Cause of action jurisdiction is same as of subject matter jurisdiction, which we have discussed in detail,
Okay, thank
right?
you. Yeah, sure. And
Hello,
one
sir.
more question. So
Sir, I
let's
wanna
say
ask a
if there are two immovable properties in different territorial jurisdiction in different places, let's say
Mhm.
one in Nagpur, other in Madurai, something like that. So in that case, which territorial jurisdiction can be taken?
The case can be filed in any of the property, that's not a problem, right?
Okay.
And you can include both the properties at once. Both the properties value.
Well, sir.
Thank you.
Yeah,
Sir, I have a question. So can I ask a
please go
question?
ahead.
Am I audible?
Yes, you are audible.
Yeah, sir, like you said, we with the plaint we have to submit documents as well. What if original document is not in my possession, but it is in respondent's possession? So in that case, how can I file my plaint and that person is not providing me the original copy? Can I serve a legal notice? And does it fall
Yes, you
under
can.
Evidence Act also? Like, can
Yes,
we take an action?
yeah,
Criminal
I
action?
understood your question. I
Okay.
understood your question. You cannot take the criminal action, but you can claim or you can go for recovery of possession of those documents.
But
It will
what if
fall
he has
under BSA,
destroyed
Bharatiya
the
Sakshya
evidence?
Adhiniyam.
But what if he
Pardon?
has destroyed the documents?
If he has destroyed the document, then nothing is left. And let me tell you, if he has destroyed the document, he himself is not allowed to use those documents in his favor also. At later stage of the suit, the court shall proceed without having those evidences. Are you understanding my point?
Yeah, but he can say
Like,
that these documents were never in my possession. So in that case, how can?
the burden of proof lies on the plaintiff. You have to prove that the documents were in the possession of the defendant. And how the defendant got the possession, the burden of proof lies on you, right?
Okay, sir. Thank you.
Sir,
Well,
as per BSA, Xerox are also allowed, right? Xerox are also admissible as a evidence.
No. Xerox are not admissible. Xerox ka certified copy is admissible, right? So as per BSA, primary and secondary, there are two category of evidence.
Right.
Secondary evidence mein there are 5 points. Like if they are generated from a same process, they can be accepted. If it is Xerox and certified, then it can be accepted, right? And
Hello,
so,
sir. Hello,
yes,
sir. May I ask you a
yes,
question? Sir, as per
please go
Bombay
ahead.
Act, it is said that a lady who is a widower or who is a divorcee, they are exempted from any court fees for asking a partition suit in her self-acquired properties or from her in-laws' properties. Is it true, sir?
To be fair enough, I don't have idea about that particular provision. I have to
Those
cross check
things
it
will be
and we'll
available
discuss in
under
next class.
legal services.
But sir, it
Those
is
exemptions
mentioned.
will be available under legal services, but not for civil suits like property and all. It might be on the POCSO, on the POSH, all these things.
So can you please explain? You can file a legal notice. When an individual can file a legal notice, a legal notice can be filed whenever you feel that there is some sort of breach of your right, or you feel that you are having any kind of right against an individual party. Nitesh, any landmark judgment for interest rate? There are numerous, right? Sir, if I reside in Himachal and I order something online from a friend for a friend who lives in Chandigarh, and the dispute arises, suppose the refund regarding the refund of the product, what will be the jurisdiction, Himachal or Chandigarh? As consideration, payment was made in Himachal, but the delivery was made in Chandigarh. Here you have to see Aditya. Here, if that case is regarding the refund, right? So the original contract was between you and that particular company, right? And neither you can file the case in Chandigarh or Himachal. It shall be filed where the company's registered office is situated or where the companies work for game, right?
Sir, can I ask you a question?
Sir,
Just
Good
1 second.
evening, sir.
Let me address the written questions and then I'll take your audio questions also.
Okay, sir. Okay, sir.
Sir, if a plaintiff wishes to sue a foreign company for an amount exceeding 1 crore, the plaintiff being in Calcutta, can he file a suit in Calcutta High Court, pleading leave? He can file a court case under Calcutta in the court of district judge, not under High Court. Okay. Pleading leave under section under clause 12 of Letters Patent Act, not barred by he will not be barred by territorial jurisdiction. Sir, how we get the suit numbers? The suit number is issued by the court. Mohit, the registrar of court, the clerk of court issues that. You can mention the relevant case laws in the plaint itself. You don't have to attach the copy of those clauses on which you are relying. Because what happens if you will mention the clauses on which you are relying, that might weaken your case. So you can just refer the name of the case if you want. Okay, I am referring this particular case for claiming this remedy. Is the plaint in High Court are more ordered and clarified than in civil court? No, no, no. They are same. Kamlesh, there is no difference. Yes, please come up with the audio question.
Sir, hello, sir.
Yes.
Sir, if a case is having a criminal FIR regarding the properties, and again on that properties a partition suit is filed, in that case is also with the court fee is meant to be paid by a person, or it is a criminal offense, so these fees are exempted.
No, no, no. You have to pay the court fee because that's a civil nature suit, which is different from criminal nature.
Means
Right?
you mean to say in every partition suit we have to pay the
court fees.
court fees.
Prescribed court.
Okay. And is there any difference between the fee structure if a lady is filing a partition suit and if a male is filing a?
In various states, there is difference. So it is based on the state amendment. For that, you can check the state amendment.
Okay,
Sir,
sir.
can we add any Supreme Court case laws in plaintiff, sir, if any necessary?
What you're saying, please pardon.
So in our plaint, we can add any supporting Supreme Court case laws regarding our case.
Yes, you can.
Thank you, sir.
Sir, this state-wise, the court fees and suit valuation acts are different, right? Like for Telangana, we have it in 1956 Court Fees and Suit Valuation Act, likewise.
Yep. For the states, they are different. Like Universal Central ka jo hai, that is Court Fees Act 1870, but some of the states amended.
So is it so that for every state it is different, or for some
No.
central?
For some states where the amendments have taken place, there that amended provision is applicable.
Okay. Sir, and this verification clause, is it same like affidavit?
Verification clause. Yes, you can say, but it is not actually affidavit. It is verification clause. It is like affidavit, but it is mentioned on the heading of verification.
So this is in both written statement and plaint, right? Verification.
Sir, yes. Sir, could you please tell me the provision of CPC that I can refer regarding notice, reply, notice, plaint, and written statement? Sai Prarthana, you can refer section 79, section 80, section 26 of CPC, along with order 6, 7, 8 of CPC.
So what is the importance of verification proof or affidavit done in the court cases of the residents?
In the court cases of the residents, can you please explain it in a bit more clarified manner? Chahat, I hope this lecture will be available later. I'm not sure. You can confirm with the moderator. Yes, go ahead with the question.
In the court cases, we see if a court order is passed, on that day also both the parties are taken an affidavit and the verification proof of their residence. So what is the importance of giving that residence verification proof and an affidavit? Is it mandatory after that?
Yes, it is mandatory. Now, let me tell you, if I am filing a suit against you, hypothetically, let's assume, I am filing a suit against you, right? And you are residing, where you are residing?
Pune.
Pune, right? So now what will happen? The court will ask me where I am going to file the suit, right? And then as per section 17 of CPC, I can file a suit against you in case of movable property where you reside. So I have to get the jurisdiction of Pune court. I have to show that you are residing in Pune. Getting it?
Means you mean to say that whatever the residence proof we are giving to the court, it is a permanent address where a person is residing. It is an evidence. It is a part of evidence.
Yes, it is a part of evidence.
Okay, thank you, sir.
Sir, so list of documents can be.
Sir, before you answer that question, I would like to say that this would be the last question of this session, and then we'll wind up because we are having you tomorrow as well, so we can continue. So this would be the last question of the series.
Okay. So the list of documents always includes Aadhaar, right?
Yes,
Aadhaar.
it includes. Now it includes. Any other question?
So tomorrow, if time permits,
Good
can you
evening,
please
sir.
show the calculation of this court fees above 3 lakhs?
It
So
it
how it is?
it will be a very challenging thing. For that, I'll recommend you to refer Code Fees Act. If you want any clarification regarding calculation, I can.
Sure, sure, sure. Thank you.
Good evening, sir. My name is Amar Preet.
Yes. Mhm.
Uh, Sir, I have just a small points to clarify. The one is, suppose a legal notice has been sent by an advocate and it has not been signed, neither he has established any registration number on the legal notice. To what extent is it void?
It is completely void. You need not to reply
Does it
back.
have any
And
validity?
no, it doesn't have any.
Completely void.
Completely
Fair
void.
enough.
It is void.
Fair enough, sir. Just a follow-up question on another point, sir. Suppose a individual who is not an advocate who sends a notice to some party, would that notice would still be referred as a legal notice, or would it be referred by as any other nomenclature? I mean, like
It,
a
it,
general
it, it will be
notice
considered a
or
general notice,
something
not a
like that.
legal
Can
notice.
it be called as a legal
It will be
notice?
no, it will not be called as legal notice. It is a general.
Okay, so that would be general notice.
Ma'am,
I
if
guess
you want,
yes.
you can wind up the session.
Yeah, yeah. So thank you so much, sir, for clearing clearing everyone's doubt and for bringing the conceptual clarity. And also, there were a lot of bombarding of the question today, but thank you for the patience. So, on behalf of everyone here, I extend my heartfelt gratitude to Mr. Sudhar Pandey, sir, for his inspiring and insightful session. Your wealth of knowledge and dedication to education and legal excellence have truly enriched us. Thank you so much, sir, for motivating us with your expertise. We deeply appreciate your time and valuable contribution. Thank you